Thank you for joining us here today. My name is Jesse Mondry. I'm a litigator here at Harris Brick, and I've been here for about 4 years. And a good portion of my practice is in the cannabis space. And I'm joined today by my colleague Jihee Ahn, who's the chair of our litigation department here. And I'll let Jihee introduce herself. And I guess, as you know, kind of the topic today is cannabis litigation in light of the current market conditions. So, yeah, Jihee.
Yeah, hi everyone. My name is Jihee Ahn. I'm primarily located in Portland with Jesse. I say primarily because I used to live and practice in LA, and I still spend, a good amount of the year down there and still do a fair amount of work there. I'm actually barred all up and down the West Coast, so California, Oregon, and Washington. I have cases in all of those states as well as New York. And yeah, I'm really happy to be here to chat with Jesse about kind of what we've been seeing for the past year or so in this space. And I hope that it's helpful and informative for everyone in the audience. So thanks.
Yeah, absolutely. And of course, I think there's a question and answer or portion of this where you can send in questions, and we'll do our best to answer those that we can. We did receive a few questions ahead of time, so we've got those in a little bit of an outline here, and we'll try to get to those. But if you did submit a question beforehand and maybe we're not getting to it or you're wondering where it is, please feel free to resubmit it again. So we're going to start today I'll give you kind of the broad overview of what we're going to do. We're going to, I think, first talk for a few minutes about what's happening in the industry and how that kind of broadly in the big swoop has affected cannabis litigation. Then I think we're going to talk sort of about some specific claims, breach of contract type things, sort of more sort of one party to an external party, I think, type disputes, right? These would be the classic, I ordered a product and they didn't pay for it. I paid for a product and they didn't deliver it, and kind of things along that line. And the next topic that we'll get into is going to be really talking about, I think, kind of disputes in closely held companies, right? So by this we mean, non-publicly traded, limited liability companies or corporations where there's sort of 3 or a dozen or so many owners, some who may be actively involved in the business or some who may just be passive investors. But nonetheless, we're seeing a rise in those disputes and a change in how we handle those disputes, or how those disputes, I think, are litigated because of the market. From there, we'll talk a little bit about collections, and then we're kind of closing down with talking about bankruptcy, receiverships, and what are called ABCs, or assignment for the benefit of creditors. So that's kind of the outline of what we're going to do today. So I'll start with sort of the introduction, right? I think everybody who's in the cannabis industry, I'm going to really focus on the West Coast here because I think that's where we practice most. That, New York is a different market, so probably because it's just emerging, so we really don't have the kind of disputes there at all that we're going to have on the West Coast. But the West Coast cannabis market is down, and everybody knows that. And so, what are a couple of causes of that? And what are we seeing out here? I think one of the big causes for it, right, is well, frankly, a really messy rollout of the regulatory framework. And in California, I think has been really an unmitigated disaster, and it's that is seriously affected the profitability, I think, and the ability to even run a cannabis business. In Oregon, the rollout was, I think, a lot more smoother, and there's been some sort of good times, but that started to dive down quite a bit as well. And then up in Washington, we're seeing something similar to Oregon. Here's a few, I think, principal causes for it, and then we'll kind of turn to how that, I think, gets to the litigation. I think one of the principal causes is the lack of federal real reform or movement. I think when we look back 3 or 4 years ago in this industry, or 5 years ago, I think there was a feeling that there was this momentum that was going that is going to push us past this envelope of federal illegality and into a space where cannabis businesses on the West Coast are going to be able to export their products to other states. They're going to be able to have access to banking like other businesses. They're going to be able to have access, they're going to have the same tax treatment as other businesses. And I think they'll be treated more like alcohol as time goes on, and less like they're sort of in this special category. And that hasn't happened, right? We haven't seen that kind of movement yet. I think it's not to say that the momentum is gone. Just last week, the Senate Banking Committee held a hearing on the Safe Banking Act, and Senator Schumer and the senators from Oregon are really strongly pushing that. But is that really going to happen this year? I don't know. It seems to be kind of every year we hear this, and I think that with our current sort of Congress, the way it's laid out across the party lines, and with the elections that are upcoming, I'm not sort of counting, I guess, on serious federal reform anytime soon. And so what has that sort of done to the industry, right? I think that has turned that, and combined with, I guess, the inflation and the federal raises in interest rates have sort of, the flow of capital into the industry has slowed quite a bit. There was a time, I think, where when there's a cannabis business dispute, right? One of the always, an internal dispute. Let's say, suppose, we've got two members of a company who are fighting about, how the company should be run, or one accuses the other of some sort of malfeasance. There was a time where a real clear option, and a fairly easy option, was to simply say, well, let's just sell the business, right? And we'll sell the business and we'll split the money. And at this time, because of the influx of capital into the marketplace, you could actually sell your business for, for a fairly good price usually, right? That typically they were based on what are called revenue multipliers when we're looking at dispensaries, right? So that would sort of mean.
And a couple of years ago, Jesse, revenue multiplier was like 1.5 times, maybe even 2 times revenue, right? So it was like a pretty good opportunity, where you can just kind of like clear your hands of the business and just walk away, and like you haven't lost much in that situation.
Yeah, that's right. That's exactly right. So you would. So you're going to go sell your cannabis business or something like that. And I'll explain the revenue multiplier thing really quick for folks who may not be familiar with it. You might look at a profit and loss statement and revenues, right? And you say, well, geez, this dispensary doesn't make a heck of a lot of money, right? It doesn't shut a lot of profits. But they weren't selling sort of really based on that. They were selling based on a multiplier of their revenue. So a 1 times revenue multiplier and $1 million in sales, you might sell your business for around $1 million, even if it was not, sort of bringing in profit anywhere near that. And Jihee's right. I recently arbitrated a case last year that was strictly solely on the issue of what is the value of a 25% interest in a dispensary located in Central Oregon, right? And the arbitrator, both sides, of course, submitted expert testimony and looking for market comps, right? This is sort of how we gauge that. And I think the arbitrator came down at somewhere about a 0.62 revenue multiplier. So then we the revenue, multiplied it times 0.6 to 25% of that, and then started doing some additional discounts, right, for various reasons. And so, that's a drastic change. And so that affects, I think, in terms of how we're going to litigate these cases when we look at what the value of the business is. Because at the bottom line, right, we're here like in the business of cannabis. So most of these disputes, they boil down to sort of, yes, what have I put into this? What can I get out of this business? And people are here to make some. The availability of money in the business then guides, I think, the litigation decisions. I think there was recently a Los Angeles Business Journal article specifically talking about California, and we could put the link up to that when we do our sort of post blog write-up, or post webinar write-up. But if you have a chance, take a look at that. I think that's pretty accurately describes some of the issues. So that's some of the big picture, right? We've got not a lot of movement on the federal issue of banking or in terms of revenue go to the ADE. We've got higher interest rates, not as much cheap money out there. In some places like Oregon, right, you've got sort of an oversupply for producers. It's driven down the wholesale price pretty dramatically, and we're seeing a lot of the small folks really struggling, which is unfortunate. And even sort of some of the bigger operations, even the multi-state operators, are not sort of reaping the kind of profits that I think everybody thought they would see, at this stage of the maturity of the market. So one of the questions we had was on tax updates, and right now I don't think we have anything really going on that I think is going to change the tax, federally wise, changes tax things. State to state, I'm not up to speed on that. One other question, Jihee, we had got was how big is the is the illegal market in California and Oregon. I have a hard time kind of gauging that. Is it out there and is it substantial? I'd say yes, but I don't know.
Yeah.
Tell you what that is, I guess, just because it's hard to track. I do know, it's got to be out there just because there were so many people who sort of, I guess, switched, went from hemp back to maybe, growing how they did before and things like that. But I don't have a sense of percentage wise. I think in Oregon, trying to sell in the state is pretty hard because marijuana is so cheap at the dispensary level. I don't know how, it's probably hard to compete at the street level, but California might be different. I think you see. What are your thoughts there?
Yeah, I mean, obviously it's not something we can find like real stats for, but I think I would agree with you. They obviously exist, and I think they obviously have an impact on the market because, just thinking about some of my past cases, some of the claims that come out of like these partnership disputes, for example, are always, they were doing this business on the side and using some of our product to fund that illegal grow or whatever. So, it definitely exists. And I think it kind of ultimately intertwines a lot with the issues that have contributed to this downturn. But yeah, I mean, there's no way to really quantify that probably.
Yeah. Let's see, just looking, we got one question, which is what type of cannabis experts might be helpful to have on your team for different types of litigation. Obviously one of the ones that I think we use in a lot of circumstances is some sort of forensic accountant in some cases, or someone with a CPA background, and somebody often who's got experience maybe in valuing these types of businesses, which becomes difficult because it's unlike some industries, there's not a great deal of public data out there, right? There's not an excellent database of sort of what these businesses would sell for, right? That problem is getting comps. So those are folks that I think are kinds of experts that we work with frequently.
So if I could talk on that for a little bit, I'm glad we got this question because I hadn't thought to really talk about experts, but and we are kind of jumping around just in terms of flow, but it's fine. So with damages experts, any situation where, for example, you have a partnership dispute and like a minority owner wants to know what the value of that company is, you're gonna need a damages expert. And like Jesse said, they use comps from as similar businesses as possible, centralizing to like that location, whatever the business is. But it's a really interesting situation, I feel, because that component is really necessary. For breach of contract claims or breach of fiduciary claims, you have to prove your damages in a court. And so you need the damages expert. But Jesse, I mean, you'll know, damages experts are expensive.
Absolutely.
And their reports take a lot of work, a lot of due diligence, a lot of review. So it's almost like you have this whole secondary team doing this huge component of your case. And I had an arbitration last year where the client, I mean, it wasn't in the cannabis space, but they were doing the same kind of thing. They were valuing the business, and the experts ended up costing basically as much as the attorneys when we were all said and done. And I feel like that's been a huge consideration in terms of whether our clients want to litigate or not, because you're effectively paying for two teams to do these two important jobs to prove up your case. And sometimes it just doesn't make sense economically or, as a business decision to put in that kind of investment. So I'm trying to remember, I mean, maybe Jesse, you remember Vince recently testified, Vince, our managing partner, and Hillary, who was our other managing partner, they recently testified as, I think, corporate experts, right? Which becomes necessary when you want to prove, breaches of fiduciary duty or whatever. I'm not super familiar with what they had to address in those cases. Are you?
Well, I know part of it was I guess speaking about sort of the standard of care, what is ordinary and customary, sort of cannabis in the cannabis law space with respect to the practice of law, whether that's drafting up things like leases or purchase and sale documents, just because there are some considerations. And so they were brought on as sort of experts to talk about that to juries in those cases. Would you want to your portion with the breach of contract side?
Yeah, sure. So, I mean, great question, but yeah, I will say, like, bottom line, I think experts are important and sometimes necessary. And the big shift that I've seen in the past couple years is, clients just understanding that you need this huge investment to have like a full-fledged team to address every area of concern. And sometimes it just doesn't make sense. So then they have to, think of their alternative options, I guess. So anyway, I was looking at the questions that were submitted when everyone registered for the webinar, and I want to thank everyone for doing that, because that really helps us figure out what topics should be discussed. We obviously want to make these webinars as helpful as possible to everyone tuning in. And I think by and far the most requested topic was breach of contract, which is not surprising at all. I would say that in any given time, maybe a half to a third of our cases involve a breach of contract as the primary claim. And for me personally, I would say that in the past year or so, the breach of contract claims that I've been seeing more of is just like in the purchase and sale context, because people are just buying things and not paying for them, or people are paying for things and not getting the product that they purchased. So that's definitely like one shift or trend that I've been seeing, is just like an influx of more simple, straightforward breaches of contract, because there's just an overall inability to comply with the agreements that have been in place. So like I said, sure.
I was just going to echo that and say that, one of the things, if you're a supplier of products to the marketplace, and you probably had some long-standing relationships and they're built on good trust, and you're used to sort of, advancing the products as sort of on a 90-day basis or something like that, 90-day terms or 30 days or something. But, I think it's really important with what Jihee's saying, she's going to explain this, is to be careful about overextending yourself in this market with how far you let things go. Think about, talking to your purchasers about starting to change the terms so that you're not sort of hanging out there so much. And it's not, you want to avoid sort of being in the situation that Jihee's talking about, where you've got to go file a breach of contract claim. And I'll just throw that in there and let you continue.
Yeah. And, on top of that, I mean, this is nothing new. And Jesse and I feel like we do this kind of webinar every year, and we always harp on how, how successful your breach of contract claim is going to be is going to come down in large part to how well it's papered. And so even, this year, we're still getting requests from clients to file lawsuits on behalf of someone who, like I said, is owed product or is owed money, but there's nothing really in writing, there are no agreements. And obviously oral contracts are enforceable, but claims involving written contracts are just so much easier to prove, which usually means resolution is usually going to come faster. And that's not just because of what the law requires you to prove. It's also because as a defendant, if you're facing the fact that there's this obligation in writing, in a written agreement that you didn't comply with, in my opinion, I think it's just psychologically more difficult to blow off something like that, or, like kind of fabricate arguments in your head against that for most people. So it's really worth the time to spend getting your sales contracts, invoices, receipts, like down, making sure that they're all organized, and just putting all that work in on the front end so that you're not trying to like cobble together this business relationship from like the 5 or 10 phone calls that you've had and like the random text messages that you sent to each other and things like that when a dispute eventually does come up. So, you know, that's been our recommendation, like I said, for years. That's not really changed since the downturn. I think what has changed in addition to just how like prevalent these situations are now is like how these breach of contract claims are being litigated. So for example, you know, we've had good clients who come to us with the good agreements, but the businesses that they've been dealing with, like on terms, like Jesse mentioned, are just kind of failing left and right. And so maybe a quarter of the time, we look at the businesses because we can do, you know, asset searches and figure out kind of what condition they're in. And we have to have, you know, the unfortunate job of telling them that, you know, it probably just doesn't make economic sense to pursue them, because winning a lawsuit, which, you know, takes a year in like the very best case, doesn't ultimately mean anything if the judgment you're awarded isn't enforceable against the defendant. And what I mean by that is, if you have this judgment and you go to enforce it against a defendant who has no assets, who has no stream of money coming in, then there's nothing that that judgment can do really for you. So overall, I feel like we've really had to counsel our clients to, number one, kind of adopt this mentality of like cutting their losses when and where that's appropriate. And number two, just being more flexible with how they approach like pursuing these claims rather than just filing a lawsuit.
Yeah, and you know, jump in and then from the other side, if we're representing the client, we do, because we're sort of on the plaintiff and defendant side, depending on the situation. You know, I think the folks who are maybe falling behind in their bills, right, and who are having trouble making these payments, you know, my advice, you know, not to a lot to these kinds of clients, and is that, you know, is to try to get out ahead of it and start working with suppliers who might be running behind. Talk about payment plans. Talk about ways you can do this. I think you're going to be better off doing that, what I see typically, than sort of letting it run up a big bill, because if you know, you probably will get sued, and you're going to have to spend money on lawyers' fees anyway, that you're just trying to defend it, even if that judgment may not ultimately be successful. And you might want to, you know, if you're trying to keep this business going, you might be a lot better off in many situations, and really trying to work out some sort of payment plan, or working something like, you know, something, you know, working together, or, you know, you've got to be a little bit creative, I think, in this down market. You know, you don't want to have something out there and going after all of your assets, and, you know, maybe they're trying to think they can pierce the corporate veil and come after you personally. It's, you know, you want to think about it. You want to think about sort of, how do I reduce my litigation budget in this down market? And then that really means a lot more, I think, communication and being willing to negotiate before things get out of hand. And we work with a lot of folks on that end. And even when we do get into these kinds of contract situations, think about, you know, maybe we want to go to early mediate first. Maybe we want to try to talk settlement sooner than sort of like, we'll just sort of let this drag on and whatever. And we got to think a little differently, I think. You know, business is flush with cash, and you want to sort of, you know, go that route. That's fine too. But anyway, sorry to interrupt you.
No, not at all. So, I mean, Jesse, maybe it makes sense for you to talk about like the closely held disputes, and then we can go into like the different options we've been recommending, like mediation, arbitration, all that kind of thing.
Yeah, sure.
Okay.
Okay. Yeah.
It's probably applicable to both.
We're going to talk about common counts. I think we had a question on that, and I don't practice in California, so I don't know what that means. What's a common count? Is there California claims?
Yeah, so common count claims can be used when you don't have precise terms. It's kind of like a more amorphous breach of contract claim. And so if you don't, you know, have perhaps every element of a breach of contract claim, common counts is kind of another way to go about it.
Okay, great. All right, so I guess the other kind of disputes we're seeing, so we've got on the one hand what Jihee was talking about, just the breach of contract, sort of heading towards a collection side of claims. And the part that I'll talk about here are, I guess what I'll call partnership or limited liability or closely held company disputes, right? So there's a couple of things to think about here, right? This is just a situation where maybe you're a majority member in the company, maybe you're a minority member in the company, maybe you've got your member managed, so you're managed by the members. Right? Maybe you've got a manager that the members have hired, or one of the members acts as the manager. And the kinds of disputes we see here, they've been happening for years, right, in the cannabis industry. A lot of them involve, maybe you've got a minority member who invested some capital into the business, predicated on the person who did not invest large sums of money, but invested their expertise, right? And maybe and things haven't gone maybe to plan, right? And the investor's thinking, well, where's all the money I put into it? Or the person who's managing it is thinking, I've been putting my heart and soul into this, and I'm not getting anywhere with it. And a lot of these these are the kinds of disputes that I mean, right? They're the sort of like the typical thing is what's going on with my money, or what's going on with the business. And one of the things to know is that in pretty much every state, right, members of a company, a limited liability company or partnership like this, they have a basic right to certain kinds of corporate records, right? And those are statutory. So, the idea, and we've seen this several times, that maybe you're just, well, I'm not going to sort of provide them the information. I'm not going to give them the information. That's not going to go very far. It's not going to work very well. In Oregon, for example, there's a statutory right to these documents that have to be provided in a reasonable time. And if they're not, the person can sue to get the documents and get their attorney's fees, which is, you never want to be in that scenario, right? So I think we can look at there's a couple kinds of lawsuits, right? Claims between members are kind of commonly what we see. And there's also what are called derivative claims. And what is a derivative claim, right? The attorneys out here, of course, if there's any in the audience would know, but the derivative claim is sort of the claim that belongs to the company, and you're going to sue on behalf of the company. So a scenario like this is somewhere where, maybe the company's got a claim, let's suppose, against a supplier, to make this really simple. It's not paying them. And you've said to the majority member, the manager, and you're a minority member, you said, hey, look, we've got to sue this guy. We've got to do this. Or you say, the majority member has been stealing money from the company. So you can bring the lawsuit sort of derivatively on behalf of the company. And there are certain requirements that have to be met for this in some circumstances, like making a demand and so forth. And there's also the exceptions to those kinds of requirements. But so the kind of claims you see there, the standard ones are things are like breach of fiduciary duty or breach of contract. And this is where having an operating agreement really comes into play, and is really important to review that closely, to know sort of what are your rights to documents under there? What are the obligations or duties of the members to each other, or the managers to the member under that operating agreement? Are they default in the statute? Have there been carve-outs? You want to take a look at that kind of thing. The other kind of claims you can get, or it's going to be declaratory relief. You might want a court to sort of make a declaration about the status of an operating agreement or a particular provision that you're going to try to enforce. Another common one that you'll use is what's called an accounting, right? This is a claim that you tie in with other claims. It's not an accounting isn't a claim you're saying, give me $100,000. It's saying, court, I want you to order, so-and-so who's in charge of the company to do an accounting of these funds or of the business or something like that, because maybe you've been, forced out of the company or kept to the side, or you're not getting the records that you want, or you suspect that, boy, it seems like we're selling, $2 million a year. Where's all that money going, right? But you're, getting refused, that sort of thing. I think another one, claim that you start to see are things like judicial expulsion, right? This is where I'm going to try to get a judge to say, throw this person out of the company for their bad behavior. Another one can be judicial dissolution. What does that mean? We're going to try to get the court to essentially order that the company be dissolved, right? We're going to sell off the assets, pay the creditors, and split what's left over. And so these are sort of like a bundle of possible claims that you can bring in these kinds of situations. And I think, people need to look carefully at which one they're going to do depending on their situation. And in this down market, one of the things, and I think I kind of was speaking on this earlier, one of the big things that's changed is just the willingness, or the potential recovery that might be there. A few years ago, if you had somebody who had invested $250,000 or $500,000 into a dispensary, and a few years have gone by and you haven't seen anything like that, and you've got it's pretty clear that you can, prove up this claim of so-and-so, the manager, somebody was improperly run, or they were, stealing money on the side or something like that. The odds of you being able to sort of get a successful recovery out of this, and this is what Jihee was talking about with how, what's your judgment worth, I think we're a lot different than they are today. And I think, for minority members, and we're bringing, whether it's a derivative claim or just a straight sort of fiduciary duty claim against who's managing the company, you got to think a lot more carefully, think about what you're going to be able to get out of it and what the real goal is. And so, some of these sort of kind of things like, and we'll get into this in a second, receiverships or ABCs, those are possibilities too, but they have their risks. But, the big kind of lesson I think today is that the money's not there necessarily in these businesses that you might be able to have pulled out of them a few years ago. And I think for both sides, whether you're on the plaintiff side or on the defense side of this, sort of better communication is really the key. And, and if you're looking like, one of the things I wish I'd see in more operating agreements would be sort of more details to the accounting, right? Because a lot of times what happens in these businesses is, here we are, we're running, it's all cash businesses, and they're using their, we just use a cash log, and you go, oh, great, a cash log, what's that? Well, somebody's writing it all down, right? And, each sale in hand, and they put the money in the safe, and then the minority partner or somebody says, well, geez, what if they're not really writing it all down? And on the other hand, you've got to then reconcile maybe a cash log with months and months of metric records or something like that. That's not an easy task. That is incredibly time consuming. And so, if you're looking into that sort of thing, if you're looking into you're still getting in this business, or thinking about redoing maybe your operating and how many you're going to do about it, thinking about, imposing certain requirements, whether it's QuickBooks or point of sale systems that are to record things, or issuing monthly reports that sort of keep you more up to date as things go along, so that things don't get sort of out of hand, and then 3 years go down the road and you think to yourself, well, geez, I've got us sued for $2 million. At this point, there's no chance of getting any money out of the business at all. See, we've got a couple of questions in here. I'll jump to them real quick. One was, I think, about, this is way off topic from where we've been, but I'll just jump into it, was about cases involving toxic torts and employees. I haven't seen those kind of cases, but I also I don't do that kind of work, and neither does Jihee. They might be. I know I have been contacted at least by one attorney who was looking into something like that, but it was sort of handled through an OSHA type regulatory situation. But I haven't seen any sort of tort claims coming out of that.
I haven't either.
Question and I think this will kind of get into next here, which is sort of our collections issue, and we'll get to this question: is what if the buying entity goes out of business? So yeah, what are your risks? So with that, I guess we've gone through some contract stuff, the kind of things we're seeing in these partnership disputes, and now we're sort of onto the third part of our talk here, right? Sort of on the collections, and we should maybe talk a little bit about default judgments as well. But Jihee, if you want to jump in there.
Yeah. I mean, I'll start with that question. So if the buying entity goes out of business, I mean, there's very little you can do, which is kind of just the sad truth of it. Jesse mentioned piercing the corporate veil, and I was going to talk about personal guarantees to kind of help in that specific situation, because basically, when LLCs and corporations are formed, that's precisely to protect the individual owners from personal liability and being on the hook for the company's debts. There are limited situations where, you can quote unquote pierce the corporate veil, and you have to show things like commingling of assets, and basically kind of have to prove up that the company was just like the owner's personal piggy bank and didn't really exist except to benefit the owner, and all of these things. But it's a really high standard that you have to prove up, and to be honest, we kind of recommend against trying unless like the facts are really great for it. And so that brings me to like a recent case that I was working on, and why personal guarantees can be a really good solution if you can come by them. Basically, I had a client who came to me post-settlement with a distributor. The distributor had basically defaulted on a loan, and the settlement that they had come up with was to assign the distributor's AR that was supposedly worth, hundreds of dollars to my client. So they reached this settlement, and ultimately trying to collect the AR is very problematic for our client because number one, as soon as, different retailers and dispensaries found out that the distributor was going under, they stopped paying and stopped communicating because they figured, they were going to be out of their lives soon. And number two, in this specific situation, the manufacturers themselves started going after the retailers for direct payment for their product. So there was a situation where there are competing rights to the AR that our client had to deal with. So all of that to say, it was a complete mess. But fortunately for our client, what they had done when they had the leverage to do so was get a personal guarantee from one of the distributors' owners. Basically, the settlement agreement had indicated that if the AR wasn't fully collectible, that would kick in, or kickstart the owner's obligation to pay the outstanding debt from his personal funds. And so that really helped our client because, in that situation when this business is closing down, if the AR was really all that our client had gotten from the settlement, they would have been in a bad situation, and it probably wouldn't have been worth it for them to pursue the EAR and possibly, get into litigation with these manufacturers for claims that don't even really belong to them. I mean, it could have been a really expensive mess, which might not be worth pursuing even for hundreds of thousands of dollars. But here, because he was able to get that personal guarantee, it can be a really powerful tool if the situation calls for it and if you have the leverage to get it. So just from my kind of personal experience with that case, I feel like I really saw the power of it and have been kind of pushing for it and recommending it whenever I can. I feel like, when you are in settlement negotiations, it's really easy to get in the mindset of like, let's just get this done, let's just hope that they comply with the payment plan or whatever it is and just be done with it. But at the end of the day, like pushing for and fighting for these types of mechanisms is really what might save it and might get you paid in the end. I don't know if you have anything to add to that, Jesse, or I can keep going.
Yeah, just to add, I think the kind of original question, what if they go out of business? One of the, in some states, and I've had an arbitration in the AAA involving cannabis right now about this, when an entity does go out of business, there is an obligation, right, to sort of sell off the assets and pay the creditors first, I think, and there's sort of an order of the things that are supposed to happen. And in some states, they're going to, and California is one of them, if you've got the facts that this didn't done, you can push towards imposing personal liability onto these owners, and that's sort of another way to do that. But it's not particularly common, in a lot of these. So if the buying entity goes out of business, it is tough, and that's why I think in the down market it's important for sellers to really think about, whether it's getting personal guarantees on these things as part of the sales, making sure there are terms and conditions that they're not getting too far out on these ARs, and trying to be really proactive and working through things. What was another question that I think is relevant to this, Jihee? Did you see that we've got a breach of contract claim against a company has been acquired or merged? Is it necessary to add the acquirer or new entity to your claim? If it's been acquired or merged, I guess it would depend on how the M&A transaction exactly. So it's classic lawyer answer is, it depends, but I actually kind of depends here. I think in a lot of situations, if you found yourself in that situation, that would be one of the first things you're going to do is look really hard at, can I do that, and is it possible to do it? And if so, my advice would I would probably want to go after that new entity or include them as part of potential liability. Typically, in most M&As, unless there's some carve-outs, the acquiring company takes on the liabilities of the purchased company. So, if it's sort of buying and selling your company as a way to sort of maybe avoid liability is really not going to get you terribly far, and it's really going to make it, I think, harder for businesses that are doing that to successfully defend claims. It starts to look like you're really just, I had a case like this too, that maybe there's somebody sort of trying to just dodge creditors and merge and sell entities. So, I think to the answer to that question is, it depends, but I think, I would say favor towards yes, but have your attorney or somebody look at that closely and see what kind of documentation you can get about that. So, let's see. Where are we at? I guess maybe into one of the other questions. Where are we at? Let's see. How can struggling businesses survive when liens and foreclosure are placed on them? I guess. So, okay, how does a foreclosure get placed on you in the first place, right? Let's step back a little bit. Is that not everybody who has a claim against you, if you owe them money and you can't pay them, that doesn't mean they can foreclose on you. Even if they get a judgment against you, right? You go through a trial or you default, right? What does default mean? It just means you never show up in court and you sort of lose automatically. And now the other side says, look, I've got a judgment, right? A judgment in most jurisdictions, and certainly out here, can act as a lien on real property, but doesn't act as like a right to foreclose. I can't walk in with my judgment and say, I now own your business, right? You've got to go through other methods of collections, right? These one of the most powerful tools, if you're on the side where you've got a judgment or about to have a judgment, because you can use this as leverage, is you can take what's called you can take a deposition of the owner and ask a deposition, right? And this is where we're going to come in and find out. We're going to find out everything about this business under oath, right? And you've got to read documents, and we're going to sort out where are all the places we can go after the money. And so this can then lead to garnishments on bank accounts. That can lead to more liens. But to get how to survive liens and foreclosures, it's not easy to do that. If someone has the power to foreclose in your business, the only really way out of it, if it's a good one, if they have a trust deed or something, is negotiation. Right? That's all you're going to do. Liens typically take effect once the sale comes in, right? Once the property or something is sold, I guess. So again, try to get out in front of these things, I guess, and work with in these situations.
Yeah, I feel like if I could add,
Yep.
What I honestly feel is most effective is just, and Jesse's been harping on this, but just like real honest communication. I have had clients who, the other side defaults on payments or whatever the case is, and my clients in the past have understood that there's a downturn and that there are limited options for people. And so generally I've seen, people be more flexible, be a little more generous and understanding, and agree to like a payment plan that, doesn't bear interest, that just ultimately gets them their money back, which a lot of people just want at the end of the day. And so I feel that if you are, a struggling business, you have liens, I think it could be really helpful just to communicate and make good faith gestures of, hey, obviously I can't pay you back the full amount today or in the near future, but could we spread this out over a period of time and like really evaluate what you are capable of doing? Because I think the worst thing to do in a situation like that is make a promise, come to an agreement and then default on it pretty quickly afterwards. I feel like there's a general distrust in the industry just because so many people are struggling, and also so many people, there are some bad folks in the industry, and I think like keeping your word, just you know, extending some olive branch that you really intend to make good on can be really helpful. And then you can just, you know, try your best and see if you can stay afloat. Yeah, because overall, like we've been saying, I think people understand that just everyone is struggling and things are not as good as it was a few years ago, and people have to adjust their expectations.
Yeah, I guess that kind of brings us to this next section. And I think one of the questions is talking about what, you know, what does bankruptcy look like these days? What does a receivership mean, and that sort of thing. So do you want
Yeah.
to speak to one of the questions we just received? But that might be the next sort of topic. I guess I'll jump in and say there was one question about something to do with IRS liability and offering compromise. And I'm not sure kind of what the question is there. I guess if, you know, we're talking about companies having tax liabilities and can you settle these kinds of tax liabilities with the IRS? Sure, I would expect so. I'll be frank, I'm not a tax attorney. I don't regularly consult or advise companies who are in hoc to the IRS or to state agencies really on dealing with those. So that might be a little beyond my knowledge, but I'd be happy to put you in touch with some folks if you do want to talk to somebody about that. Send one of us an email. But yeah, so, you know, so we go from collections. This is on the, you know, you're trying to get the money side, and, you know, how do you do that? I think if you're the collector, you've got to be flexible, like Jihee says as well. You know, having the big stick, even if you've got, you know, even if you've got a great contract and you've got attorney's fees, and you can do this, you can really lay the hammer down. You know, is your goal to sort of lay the hammer down? Is your goal to start getting money coming in? And if you've got if you're dealing with a struggling business, you know, you probably want to start having the money come in sooner rather than going through, you know, a 3-4 month negotiation or litigation process to get to the same point you would have, and realize that, you know, unfortunately, sometimes, you know, you're going to lose some money in these things, right? There's risk in business, and we hate to look at it that way, but it's got to be a part of the calculus here. And it's hard to make those business decisions instead of emotional decisions. But it's really important to do that in these kinds of situations when, you know, when you take a hard look at it with your attorney or with your, you know, your business partner, and you look at what are the real odds of collecting on a judgment here. You know, I know we had a case that went to trial last year, and, you know, we ended up, you know, prevailing on all, you know, it was a good trial for us. We prevailed on all counts, and we even got a judgment against the other side of, you know, into the 6 figures easily, you know, decent sized judgment. But, you know, since that time, we haven't gone out and do anything, because first thing we did is we went and hired somebody who knows how to sort of do an asset investigation. We realized, well, you know, you're not going to really, the odds of actually doing aren't great. You know, you might take if you're in that situation, you might hand it off to somebody who's a collector who's going to take a percentage of it. But most of those folks look at it too, and they say, well, what are the odds of my collection on it, right? And you know, but was it worth it to my client to pay me another, you know, 10, 15 or whatever, however many $1,000 to go after money that he would probably never see? No. And so he's kind of made the decision to sit on it. A judgment is good for years, so it's not that, you know, if he doesn't get the money right away, maybe this guy wins the lottery tomorrow, maybe not, but, you know, in the short term, it doesn't make sense for him to keep putting money into it. So, but yeah, bankruptcy, what's going on there?
Yeah, so I'm trying to catch up on the questions because we've got a sudden influx then. Someone asked, if a sale contract has terms for monthly late fees but not for non-payment, what is the time frame before one can pursue a legal claim? So I don't want to be annoying, but, you know, it would help to know what the contract says. But generally, your claim accrues, or you can sue as soon as a non-payment occurs, right? And some contracts have like cure periods and notice periods that you need to comply with before you can technically file a lawsuit. But yeah, it's going to be determined by the exact language of your contract and whatever obligations you have to comply with. You don't have to wait like a lengthy period generally, like, you know, doesn't mean that like the monthly late fees have to amount to a certain amount before you can file a lawsuit or anything like that. Statute of limitations for breach of contract is 4 years in California, I believe.
I think it's 6 years.
4 to 6 generally.
Yeah, you wouldn't usually wait that long. You know, if the
Yeah,
company's silent on it, the court's going to say, well, what's a reasonable time probably? Or you might look at, well, what was your history? Were they ever making payments? How did that usually work?
right.
But there's no need for you to wait, more than, I don't know. I wouldn't certainly wait 4 years or, a year
Yeah,
even close to that statute of limitations.
yeah, definitely. And yeah, okay, so turning to bankruptcy, someone asked a very nice transition question. Can a person slash business owning on a written contract bankrupt out of the obligation in the cannabis space? Basically, the answer is no. So, as I'm sure some people are aware, the option of bankruptcy is just, it's not available to cannabis businesses and some cannabis adjacent businesses. The courts have been pretty consistently holding that debtors who work in the industry or I think the key phrase is derive meaningful income from cannabis activity, whether that's directly or indirectly, cannot use bankruptcy because bankruptcy is a federal mechanism, and as long as marijuana remains illegal under federal law, you can't do it. Here and there, over the past couple of years, there have been decisions and opinions where a bankruptcy court will break away from that trend, but that is in like very limited and specific scenarios. I won't go into detail because we're nearing the end of the hour, but I recently wrote a blog post on a recent decision, I think in the Central District of California, where essentially the distressed cannabis business had divested its assets into a Canadian company and received Canadian stock in return. And basically, the court allowed them to use bankruptcy because cannabis was kind of part of their prior operations, not their current operations. And so overall, if you're in a situation where like the debtor divested cannabis from its assets, then maybe it could, go to bankruptcy court. But generally, a cannabis company isn't going to be able to reorganize under Chapter 11 or liquidate under Chapter 7 if it's still a going concern with cannabis products. So, I think overall, dicta and the message of the opinion, it's still like marks a break from the zero tolerance policy that the courts have traditionally and continue to use. That's typical for these cases, but I think in like limited circumstances and in very specific scenarios, they will break away and afford bankruptcy. Yeah.
Yeah. So, a couple other options, I guess, in this kind of space. One is receivership. I'll tell you, right, in this climate, what is a receivership? This is essentially where there's a receivership is where we're going to take a company and the court is going to appoint a third party who's not involved with the company, right, whose job is to muster all the assets, liquidate all the assets, pay off the creditors, and then see where that goes. So, I mean, you think of, what do we hear in the news about this, Sam Bankman-Friedman and the collapse of FTX, and they appointed some guy to run the company. He's sort of acting, coming in as a receiver, right? I think in some sense, or you see that with big companies in cannabis space. You can certainly do that. Those are state options, not a federal option, so you can do that. The trick, though, I think, is that the receiver gets paid, and it's a fairly cumbersome process, and so it's not necessarily a great solution. If you're a creditor of the business or a member, maybe who has some ability to try to force a company into receivership, it's an option, but think carefully about going it the court way. We have worked in a case where we sort of hired a private receiver essentially and did a private contract because we were able to kind of cut down on a lot of the, I don't want to, sort of the not rigmarole is not the right word, but sort of some of the formalities, I guess, of a court receivership. So that's maybe an option. An assignment for benefit of creditors. This is, we're pretty close out of time here, but I think we've done one of them in Oregon. I think Vince was involved with it, and to our knowledge, it's the only one where the creditors essentially were able to take control of the license and control of the business through the OLCC and have that assigned to them. And that's an option. It's not going to be a cheap option. And the thing to think about there, of course, is do you want to end up owning and having to run this business or not? But it's also, if you're on the debtor side, it's maybe an option for you to say, well, let me get out of this, and if you can negotiate a way to hand that off and not take on any liabilities, it might be an option for you.
I feel like receiverships are becoming a little more common. I still haven't seen that many ABCs personally. I think a receiver can be really good, especially in the context of like these really heated partnership disputes where like there's just a complete breakdown in trust. And so, in that kind of situation, if you bring in a receiver who you definitely want to be well-versed, in the cannabis industry and business and understands how to handle things from like sales and accounting to like personnel and stuff like that. I think it can be a good option. Generally, I feel like clients have not liked receiverships because they're obviously relinquishing control of the business, and they don't necessarily like that. But at the same time, again, if you like suspect that your partner is like not motivated or maybe even sinking the ship intentionally, or like stealing money or things like that, a receiver can step in and like make sure the business is being run optimally while you handle your partnership dispute on the side. So I think it's like a good method to stop any unnecessary bleeding in the meantime. But yeah, I think another consideration is that receivers typically bill maybe on an hourly basis like we do, and they take their fees from the business in most cases. So like, in this atmosphere or like in this current climate of a downturn, it might not necessarily make the most sense for most businesses. But yeah, you just kind of have to like weigh the pros and cons of your options.
Yeah. That's probably about it, unless there's any more questions anyone has out there. Thank you very much for your time. Hopefully it was helpful.
Yeah. I think I just see maybe one question we didn't address, which is there a recognizable trend or difference in how courts rule on distressed businesses cases in California, Oregon, and Washington? I don't think so. I haven't felt like the cases diverge greatly from one another depending on where they're filed or where they're litigated. I will say, I wanted to touch on arbitration and mediation, but we just don't have the time for it. But I will say, a lot of people have tended towards like mediation and arbitration because I think you have a little more power in who you're working with. You get to choose your mediator and arbitrator, and it's kind of good in these situations, in situations like a downturn, to have someone who's knowledgeable and just understands, like the typical results might not be available or can be a little more creative with you about, what kind of resolution you're looking for. Yeah, so to answer the question, I don't see any recognizable difference or feel any difference. I think Jesse agrees based on his nodding. So yeah. Yeah.
Thanks very much, and please send us any feedback about things you'd like to see us do in the future. We are going to plan one in the next little chunk of time, maybe next quarter or something like that, towards the end of the summer. Yeah, good luck to everybody out there, and feel free to reach out anytime and give us some feedback. We really appreciate that. That helps us provide content, I think, that can be useful to you. So, and that's our goal here. So, what do you think?
Yeah, we typically do like a follow-up post on our blog, so you can still submit questions and we can turn them into blog posts for the future and things like that. So yeah, thank you again to everyone. I hope it was helpful, and thanks for your time.